Welcome to EUPrivacyForAll, Session 3 on the GDPR published in May, Article 6.4 on further use of data. Article 6.3a was renumbered Article 6.4. This provision outlined that where the processing for a purpose other than that for which the data have been collected is not based either on data subject's consent or union or member state law, the controller shall, in order to ascertain whether processing for another purpose is compatible with the purpose for which the data are initially collected, take into account any link between the purposes for which the data have been collected and the purposes of the intended further processing, the context in which the personal data have been collected, the nature of the personal data, specifically whether it aims at processing special categories of data or criminal convictions and offenses, the possible consequences of the intended further processing for data subjects, and the existence of appropriate safeguards, which may include encryption or pseudonymization. Recital 50 stresses a key point. Whenever a further use of data is envisaged by a controller, it has the obligation to carry out a compatibility test. Where the processing is compatible with the purposes for which the data have been initially collected, no legal basis separate from that which allowed the collection of the personal data initially is required. On the contrary, if the compatibility test fails, another legal basis separate from that which allowed the collection of the personal data will be necessary. Archiving statistical purposes should be considered as compatible. Also, legal basis provided by union or member state law may provide a legal basis for further processing. Where the data subject has given consent or a legal provision is provided in the union or in a member state, the controller should be allowed to further process the personal data irrespective of the compatibility of the purposes. Additionally, indicating possible criminal acts or threats to public security should be regarded as being in the legitimate interest pursued by the controller. However, such transmission or further processing of personal data should be prohibited if the processing is not compatible with a legal, professional, or other binding obligation of secrecy. The Directive lays down in Recital 28 that the purposes of processing further to collection shall not be incompatible with the purposes as they were originally specified. The following recital stresses that historical, statistical, or scientific purposes shall not be generally considered as incompatible, and suitable safeguards should be provided. Article 6.1b of the Directive also reminds that Member States shall provide that personal data must be collected for specified, explicit, and legitimate purposes and not further processed in a way incompatible with those purposes. What should accountable data controllers get prepared for? First, they will have to know that further processing of data requires to identify whether it is compatible with the purpose for which the data are initially collected. If not based on consent or an EU or national law, the controller shall assess compatibility of this further processing using the following criteria. First, any link between the purposes of collection and the further processing, the context of collection, that is to say the relationship between the data subjects and the controller, the nature of the personal data, is it sensitive, criminal convictions and offenses, the possible consequences of the further processing for data subjects, and finally, the existence of appropriate safeguards, including encryption or pseudonymization. If further processing is compatible, no separate legal ground is needed. If a data subject consented or national or EU law allows further processing, no compatibility test should be carried out. The further processing for the public interest, that is to say scientific, historical, statistical research, is deemed compatible. Finally, the controller has the right to share on possible criminal acts or threats to public security with competent authorities, unless bounded by a legal, professional, or other binding obligation of secrecy. So the question triggered now is knowing whether the Working Party 29 guidance, and notably its opinion 03/2013, will be enough to be framing the compatibility test.